Thank you all for coming today to the first of our presentations in this year's Student Scholar Series. The series was instituted 12 years ago now. Wow, y'all all got old, and I didn't. In order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by a third-year student, Claudia Shannon. Before I introduce Claudia, I'd like to introduce the respondent to her presentation, Professor Daniel Zackham, who has done this so many times. I've kidded with him before. He does it so much because so many people whom he advises win these things. And so his guidance and expertise is particularly appreciated, and the time he takes to come to finish this process we're very grateful for that. He's a 1980 graduate of GW with a degree in political science and a 1985 graduate of our law school. Following graduation, Professor Zackham served as a judicial law clerk to the Honorable Frank Q. Nebaker, is that correct? Of the District of Columbia Court of Appeals. Served for 2 years as a staff attorney at the United States Court of Appeals for the District of Columbia Circuit, and thereafter worked for 22 years as an assistant United States attorney in Washington, D.C. Last 10 years career as a U.S. Attorney's Office was spent as a supervisor in the homicide section. Following the U.S. Attorney's Office, he taught criminal procedure at AU, joining the adjunct faculty here at Catholic University after that. He teaches criminal law, criminal procedure, the investigative process, criminal procedure 2, the post-investigative process, and advanced criminal procedure, anatomy of a homicide. He has been honored on multiple occasions as Evening Professor of the Year and Adjunct Professor of the Year for his classwork here, and he's helped us in this capacity, as I said many times. We really appreciate him coming here today. As to Claudia, she is a 2015 graduate of the University of Maryland, College Park. She has always had an interest in pursuing a law degree and seeking a certificate in civil and criminal litigation. Last year, she participated in the Journal of Law and Technology as an associate and currently serves as a note and comment editor. She also served as a member of CUA's Law Moot Court Association and won the Hennessy Moot Court competition last year. So she wrote this particular article due to her interest in connection in the connection between direct-to-DNA websites, the Fourth Amendment, and law enforcement's use of these websites to catch cold case killers. So I'll turn the floor over to Claudia Shannon. The title of her presentation, DNA Websites, Are They Becoming De Facto Universal DNA Databases? Claudia.
Hi everybody, my name is Claudia Shannon. I'm a third year here, and we're here to talk about the article that I wrote for the Journal of Law and Technology. A little bit about how I came to decide to write this article. My mother and my sister actually received one of these kits for their for Christmas in my first year. And fast forward to April is when the Golden State Killer was caught, and he was actually caught using one of these databases. I started researching topics to write my journal article on in the summer, which is when I received an email from Professor Zackham to the entire criminal procedure class about taking note of certain Fourth Amendment privacy cases that really stressed the importance of keeping one's personal information private and what access law enforcement has into that, whether that's Riley, Carpenter versus the United States, Maryland versus King, Smith versus Maryland. These are all cases that I'll be talking about a little bit later, but they were relevant in determining, really linking how I wanted to approach this article and whether DNA databases pose a threat of having a universal these DNA websites pose a threat to having CODIS-like tendencies with law enforcement. So before we get really started, I wanted to talk about a few background basics that I'll be talking about later on. The construction of these websites, you really, as a consumer, it depends on what they're paying to have constructed and depends on the website that they are going to be taking part in. So 23andMe, Ancestry.com, Family Tree DNA, these are all websites that link a person's lineage or heritage, and they can link various people together, or the consumer can just find out more about their personal lineage, which those are the crux of the websites that I'll be focusing on today. There are other websites where a person submits a cheek swab or a DNA sample of some sort, and the website can come back and tell them exactly what sort of diet they should be using. So it depends on what sort of information that the consumer actually wants. The consumers usually pay between $50 to $200 for one of these kits, so it just depends on the various site. I'll also be talking about what is a known versus an unknown sample. In this context, unknown samples are DNA materials of the unknown suspect being compared to a known sample collected from a DNA website. So when an identified person, like a direct consumer, submits their saliva to 23andMe or Ancestry DNA, it can be considered a known sample because the source of the DNA material is known and identified. DNA matching is basically a concept of probabilities. If you acquire similar profiles, the testimony of a technician, the odds show just the odds of that alternative match. So the conclusion isn't going to be that this person is the actual match. It's going to be whether the chances of the similarities of the individual being one of another is 500,000 to 1. Familial matching is essentially the crux of what I will be talking about today, since that is how most of these killers in the news have recently been caught. And it's based on the basic concept of family members share DNA. Typically, direct DNA matches are often unable to be made when using traditional DNA databases like CODIS or like the National DNA Index System, because the owner of the DNA has never been arrested or convicted of a crime. The crucial difference between these former DNA databases, as I've said, is that the consumers usually have not been convicted of a crime, so they're unknown. By employing familial searching, some states are quietly expanding database coverage to include innocent relatives absent any legislative oversight, which is what I'll be focusing towards the end. The thesis that I really talked about already is that websites like Ancestry.com, 23andMe, Family Tree DNA are using partial DNA matches and familial matches from these websites and comparing them with DNA gathered from cold case crimes. Really, I'm trying to my article weaved into the various Fourth Amendment intricacies and nuances and whether those are Fourth Amendment search violations or not. There are, as I talked about, this is the Fourth Amendment. Most of you probably know what it is, but it's just the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized. The three cases that I really focus on in my article are these, they span from 2015 to 2018. The Fayetteville Ramsey Street rapist was someone that was caught using one of these websites where the officers used an online genetic database to solve this particular murder. The NorCal rapist was an offender who committed various sexual assaults and robberies of at least 10 women between 1991 and 2006. Law enforcement discovered a partial match to the DNA of one of these defendants' relatives in the same database, GEDmatch, by developing a family tree and confirming a match through the defendant's discarded DNA. The Golden State Killer is the case that I really focused on, and it's what really inspired this article back in 2018, and this case marked a turning point in law enforcement's history in using DNA analysis to capture criminals. Joseph DeAngelo faces currently 13 charges for murder and 13 rape-related charges for crimes committed in the 70s and 80s across 6 different California counties. He was able to avoid capture for so long because of his own role in the law enforcement community as a police officer. So he really knew the intricacies of how to avoid capture during that time and then stayed dormant. And he was only caught after authorities created a DNA profile that they uploaded into GEDmatch, which is a website that connects Ancestry DNA, 23andMe. Any user that uses 23andMe, Ancestry DNA, or Family Tree DNA can upload their profile to GEDmatch as well, and that particular website will link other users from those other websites. So it's a mass pool of DNA databases that can link other people to other users. The company in that particular case, GEDmatch, stressed at the time of his apprehension that although they were not approached by law enforcement authorities about his presence or the DNA in question, it has always been their policy to inform users that the database could be used for other uses. The general privacy concerns, as I've sort of hinted on, are that consumers are used to agreeing to long privacy agreements without actually reading them. But if these privacy agreements have to deal with their genetic data, they may not be entirely aware of the serious privacy risks that accompany this agreement. Essentially, DNA is one of the pieces of one of our pieces of property that is the most, it's one of the most important things that we own as human beings. And some people, while checking that box, may not be fully aware that they are allowing law enforcement to use it to catch a criminal. And while that may be noble in a regard, it's also something to think about in terms of privacy concerns. The use of familial searching is a distinctive matching method in its own right, since it's highly unlikely that family members are even aware that their own DNA following a submission to a direct-to-consumer website could be accessed by law enforcement and then used in their subsequent investigation. What makes it so dangerous is that it's essentially creating this CODIS-like system by extension. And that's just something that we should think about before, clicking I agree or clicking an agreement to one of those terms and conditions. The principal issue that I face in my article is standing in regards to who is affected under the Fourth Amendment, because consumers' willingness to share such deeply personal information raises these questions about whether they truly understand what these transactions mean for their privacy rights. Aggrieved parties under the Fourth Amendment are typically those who have convicted the crime, and that's where you would use that sort of relief through the exclusionary rule. In my instance and in my article, the aggrieved parties are the consumers who submit their DNA to these genealogy websites and unwittingly open the door for law enforcement to use their DNA to catch a relative suspected of committing a cold case crime. Traditionally speaking, the traditional Fourth Amendment doctrine suggests that the target would not properly complain of the profile because they don't have a reasonable expectation of privacy in the precise area that was the subject of the search. The exclusionary rule remedy only comes into play if the complaining party is ultimately charged with the crime and the government charged with the crime and the government seeks to introduce evidence acquired. A person who provided a DNA submission and is not charged with that crime does not currently have standing. And that's also something to think about in terms of potential remedies that we can, further down the line. The issue in determining whether a search by law enforcement is unreasonable is whether the defendant had a reasonable expectation of privacy in the place or thing that was the object of the search. The defendant likely abandoned their unknown sample of DNA at the crime scene and therefore, by their own doing, gravely limited their privacy rights in regard to this abandoned DNA because police are capable of acquiring the sensitive genetic information without being subject to the criminal rules that normally apply to searches and seizure. The thing is, we abandon our DNA all the time. Right now, people are drinking Coke cans and water and anything like that. That's something that can be abandoned on the crime scene and easily used within a police officer's purview. In my regard, the known sample was acquired from biological material that was voluntarily surrendered by another person, by a family member, who may not know that by doing so, law enforcement is now going to have the opportunity to use that to catch a criminal. Some of the potential benefits that also, or alternative arguments against my article, which have validity and are important to note, is that the technological advancements have been increasingly beneficial to law enforcement agencies in regard to criminal investigations. The obvious one is that DNA testing has the unparalleled ability to exonerate the wrongfully convicted and to identify the guilty. This provides the benefit to improve both the criminal justice system and police investigative practices, specifically with racial disparities. We know that it's known that more than 60% of the profiles put into these websites are of people of European descent, so wouldn't it make it more relevant since there are more people likely put in the CODIS system in the National DNA Index database that are comprised of non-white individuals who may have been wrongfully convicted. So for law enforcement to use these DNA databases to catch these cold case criminals is a decent argument to sort of balance and rectify that entire issue. So to move on to my next section of the article, which really talked about these three different important Supreme Court cases that really focused on the privacy concerns under the Fourth Amendment. And it starts with Maryland versus King, where that court ruled that when an officer is making an arrest for a serious offense that is supported by probable cause, and they bring the suspect detained into custody, taking and analyzing a cheek swab of the arrestee's DNA is a legitimate police booking procedure. What's distinguishable about King and a familial match using a DNA website, DNA database, was that the suspect in King was already in police custody for a serious offense supported by probable cause. What makes familial searching so distinctive is that it's unlikely the person submitting their DNA at the time is even aware that their DNA, compiled by a direct-to-DNA consumer website, could be used to apprehend a member of their family that is suspected of committing this crime. Even further, the relatives and their DNA are unknowingly accessible to law enforcement in their own right and can become potential suspects or persons of interest despite possibly not even having been convicted of a recordable offense. So essentially, familial matching widens law enforcement's interest into potential suspects based on their family members' past dealings in the criminal justice system, and makes a platform that functions as a de facto DNA database filled with people who have never been convicted of a crime. As stated, the danger that familial matching poses to the Fourth Amendment is that familial matching could just as easily fall into something akin to a general warrant, which is something that Justice Scalia and Justice Ginsburg both agreed with in their dissent. And that's something that we should keep in mind, and something that was actually built upon in Carpenter versus United States with Justice Roberts' opinion, where he noted that a person does not surrender all their Fourth Amendment protections by venturing into the public sphere. That case specifically dealt with, it held that the location information obtained from a wireless carrier constituted a Fourth Amendment search, and an individual maintains a legitimate expectation of privacy in the record of his physical movements captured through CSLI, where essentially that person that's holding the phone, the government was able to retrace a person's whereabouts subject only to the retention policies of the wireless carriers, which currently maintain records for up to 5 years. So the standard for electronic data is so high due to the quality of information that it provides that allows for the government to gain intimate knowledge of the individual's life by merely tracking their cell phone. So it could be argued that that standard should also be applied for personal genetic data of an individual. The final case that I really talked about in my article is Smith versus Maryland, just because that is the one that has it poses the most damage to my argument in terms of the third-party doctrine and assumption of the risk, where in that specific case, which was, I believe, early 70s or 80s, I think, the police installed a pen register at a phone company's central office to record numbers dialed from the suspect's home. This particular suspect had robbed a woman and began to proceed making threatening phone calls. So they attached the pen register at a phone company's central office and used it to determine that this person who was calling the woman was the suspect in question. That case specifically ruled that a person has no legitimate expectation of privacy and information voluntarily turned over to third parties. The person that's acquiescing the information takes the risk in revealing their affairs to another, that the information will be conveyed by that person to the government. So arguably, Smith versus Maryland does the most damage to my argument, but it should be asked if this argument also applies to familial matching, where although familial matching has arguably led to the apprehension of bona fide criminals and the exoneration of the wrongfully accused, there is a stark difference between a convicted felon and an innocent consumer. As a convicted felon, that person has forfeited their privacy rights by committing said felony. It does not also follow nor automatically imply that the person's law-abiding family members have also forfeited their privacy rights. I've added two of the terms and conditions from GEDmatch and from Family Tree DNA, because those are the two websites that I really talk about in my article, where GEDmatch is one that it was very hidden at the time when I was doing my research, where they have a particular discussion of saying that a consumer should not upload their DNA data to the site if they're concerned at all. And Family Tree DNA is a website that recently, back in the fall of 2018, came under fire when they released information stating that they had been helping the FBI with 10 cases without letting their customers know that they were sending this DNA to law enforcement agencies voluntarily. Ironically, Family Tree DNA was the most recently named the best direct-to-consumer DNA kit for research and privacy by the U.S. News. Possible remedies. So something that came up in my research was the Genetic Information Non-Discrimination Act, which specifically is a federal law used to prohibit discrimination in the employment and health insurance context. It's something that I think would be helpful in fixing this issue, where a solution for anybody that cannot seek redress under the Fourth Amendment should seek a solution via the legislature. GEDmatch has also recently updated the terms of services as early as fall 2019, saying that police are now allowed to use its DNA database to solve all violent crimes, including non-negligent manslaughter, aggravated assault, and robbery cases. Essentially, it's important that consumers know before clicking I agree or scrolling through that 9,000-word terms and conditions sign that they really should look at it and make sure what are they actually releasing. There are some sites, there is one site as of right now called EncryptGen, which specifically gives the consumer the ability to determine who gets to see their information. So that's something that could be also a remedy as well. At this time, I'm going to pass it over to to Professor Zackham, and he will conduct his response. Thank you.
Claudia, just a couple of questions. If we focus on who's complaining, just put on a general category of who's complaining. If we look at it from the perspective of the person who's ultimately charged with a crime, is it not true that current legal principles would suggest, that you've already noted, that that individual lacks standing as a federal constitutional matter to lodge a complaint because the DNA profile that the government constructs from the crime scene is biological material that he abandoned and gave up any reasonable expectation of privacy in that material, and there's been no other material relevant to him that has been searched by the government?
I would say, yeah. I think that, again, I think it's hard to determine, as a family member of the person that was convicted of a crime, you don't have standing at all. And that's the issue, I think, under the Fourth Amendment. I think that there has to be some sort of redress in terms of the legislature or anything like that, or state precautions that are made that specifically bar familial matching. I think that that's part of the issue.
If we look at it, if it's the consumer who's complaining at the end of the day, is it also not true that current legal doctrine, as you just noted, beginning with Smith v. Maryland, and even as Smith v. Maryland has been subsequently interpreted by the Supreme Court in cases such as Riley and Jones and Carpenter, that the assumption of the risk doctrine first established in Smith v. Maryland is still good law?
Yes.
So from a federal constitutional perspective, the consumer has a significant legal hurdle
Yes.
to complaining in that regard. And can you also tell us a little bit about, is it also not true that when we all surrender some degree of our privacy, as we do every day we do an internet search, we decide, I want to potentially buy a pair of shoes, and we do a little bit of search, and within seconds we're bombarded with spam from different shoe companies trying to sell us their product. If we engage in that activity knowingly, that we know that in certain instances, similar to your example here, that we're drinking out of cups and cans and we're leaving some manner of biological material on the cup or the can, we get up and leave the room, or we deposit the can in the garbage. Again, we're knowingly depositing our biological material, and we're abandoning it and someone come along and pick that up and use it for their purposes.
Absolutely.
Right? So we can say that it's not my subjective, purposeful intent to disclose my biological material, but I'm doing it knowingly. I know it's a consequence of my action.
Yeah.
And does that also not pose a hurdle to any redress by the consumer?
I think so, and I think one of the overarching themes that I really took from looking into these cases was that not all privacy is essentially the same. It's not one size fits all. And I think that really came about with Carpenter, where they really talked about the difference between holding a cell phone versus, I think it was in comparison to Jones, where they were willingly driving on a public freeway. So I think when you, especially when you're carrying a device like a smartphone, and you log in, and all of a sudden, someone has access to your personal information, and that's on your person at all times. For me, I find that to be equitable to something that you carry around with you every day, and you can deposit at any point, which is your DNA.
Mm-hmm. Well, is there a difference between, like, probably every single one of us in here, we have, our ubiquitous little phones that we now find that we can't live without, that as soon as we power it on, that this device is going to send signals to cell towers and start pinging, and we're not doing anything.
Yeah.
I'm not sending emails, I'm not talking on the phone. My device is doing it automatically when I powered it on. And is it acceptable, a societal matter, to say, well, these have now become essential devices in our life, and to power it on is necessary to use it, and so we're not doing anything affirmatively to send that information out. Contrast with the consumer who sits in their home and says, you know what, I'm really curious as to whether or not my grandparents really come from Ireland as they've told me. I'm choosing to stick a Q-tip in my mouth, take some biological material, which I admittedly have a right to privacy to, and I'm choosing to stick it in an envelope and send it off to a company. Is there a difference between the cell phone example and the 23andMe example?
I think the difference is that consumer, they may be voluntarily surrendering it for the purpose of having their DNA tested for lineage, but they're not specifically aware of at that time that law enforcement is using using their DNA in some manner to catch a cold case criminal.
Okay, so it would be, is it somewhat akin to the example of, with apologies to you because you've heard this before, it's the same tired analogy that I use 100 times, that if we get a call tomorrow from our best friend from college who says, I'm taking a road trip down to Florida, I'm going to stop in DC. Do you mind if I stop and stay at your house? And you say, sure, and you grant some measure, you give up some measure of your privacy to that individual, and you can say, there's the bedroom you can stay in, and there's the guest bathroom, and you can use that. And then you go off to work, and you come back at the end of the day, and there's a wild party going on in your house, where your guest has now taken your invitation and expanded it to 15 other people. And now you've got pizza boxes and empty beer cans all over your house, where you have the ability, under those circumstances, to restrict your privacy, to say, I'm giving access to you to have this part of my house for this limited purpose, so I can limit it. Is that consistent with Smith v. Maryland or inconsistent?
I would say that that's probably consistent with Smith versus Maryland, since they're taking the assumption of the risk, but I would also look to...
That's when you say the assumption of the risk, that the Supreme Court has told us that if I grant access to my friend to come in the house, that I assume the risk at that point that he is going to take it upon himself to invite other people. And the example, the analogy would be 23andMe inviting the government to come look at my DNA sample.
Yes, because as consumers are now clicking that box, but they are not necessarily aware of when they're doing that law enforcement, it's only been recent that law enforcement has been using these databases and these websites since 2015 on. And that's just something that I think in this growing age of technological advances and privacy, all these privacy issues are now coming to light, and that's just something that as consumers we should be aware of.
One thing that you also touched on, which is fascinating, is that statistically, is it a fair inference to say that the CODIS database, it's a government-maintained database, correct? and it's populated by DNA profiles constructed from biological material that is taken from persons in the criminal justice system.
Correct.
Right? Arrestees or persons who've been convicted. And there is a significant amount of regulation of that database, for the maintenance of that database,
Yeah.
correct? Is it a fair assumption that that a great number, if not a majority of the profiles, DNA profiles contained in law enforcement's coded database belongs to people of color?
Correct.
Okay, because of various inequities within the criminal justice system at large. Would it also be accurate to say, and I think you alluded to this, that because the genealogical websites, A, cost money, and B, are a luxury, where people do it not because they have to, because they want to and they choose to, that we can make it an assumption, is it a fair assumption, that based on socioeconomic status and so forth, that the profiles contained in the consumer databases are largely of white European descent?
Mm-hmm.
If that's true, and we're talking policy and where the law should go, can an argument be made that, well, you know what, it's a pretty good thing to allow law enforcement to have access to those databases, because it evens the playing field a bit in terms of the scope of their investigations, that more white folks are going to be included within the investigative sphere? Can that potentially be a good thing?
I think so, and I think that's one of the downsides to my argument. I think that is definitely a benefit that should be considered. It's just a matter of the privacy concerns and towing that line, because I do think that DNA matching, one of the biggest draws to it is that it has that ability to exonerate the wrongfully accused and convict the guilty. So when we're looking at that side of it, there is a huge benefit to using these websites. It's just a matter of the privacy concerns that lead to apprehending these criminals.
Thank you.
So, thank you.
We'll have some questions here.
Yeah.
Try to end in 15 minutes. I'll take the prerogative to ask people real quickly. Explain to me, it wasn't clear to me, this part of it. How is it that they get to the North Killers? Do they know that his, do they say, okay, we suspect him, let's ask, we know who his brother, sister, mother, father are, and we ask for theirs and see if they have done it, and if they have, we get theirs. How does that work?
So that was similar, his apprehension was similar to the Golden State Killer as well, where they had an unknown sample of DNA from the crime scene. And they used GEDmatch to construct a familial tree, and that's how they found a relative of his, and were able to pinpoint him as the killer that way. So they found a relative, and they knew that they had a certain amount of matched loci in the DNA sample, and knew that from that sample, the half-brother that had uploaded
So
his
they
DNA.
take the DNA,
Yeah.
then they see if they can find somebody in.
Correct.
I see.
So.
Okay, and then a little quick follow-up question. Is this, I mean, we got to the point where one of the things that's questionable is any expectation of privacy at all, period, anymore. I mean, is it not on law enforcement side, so, because you were saying, I had no idea that was going to happen when I sent in my spit test. I had no idea they were going to do that with it. But, enough of this stuff gets around, and then we say, how come you didn't know? Because they're catching all these people because of it, and you should have known, and, just that things that we can, I want privacy in all kinds of ways, but I don't have any expectation we'll get it because of, Google's all over the place, and it sees me in my backyard, and I really don't. I'm always thinking there's a camera around now. And is that whole concept, becoming something that is of, debatable value?
I would say so. I think that, again, privacy is not a one-size-fits-all sort of situation. So when you're having a conversation with someone, or it's a criminal conversation, and that person winds up being a confidential informant and then goes to the government to disclose that information, you are under the, and I think that there is a specific case that says that you are disclosing information that, or taking the assumption of a risk, that you are disclosing that information for that information to be handed over to the government. Versus with Carpenter, where you're carrying around a cell phone that has the CSLI information and it's pinging off different cell towers, you are letting the government know as to your intimate whereabouts. And that leads into this conversation of the mosaic theory, where if the government can piece together all of these little bits of information and get an intimate, detailed knowledge about you, that is an invasion of privacy in some regard. So it really, I think, depends on the situation.
If your question's a great one, because in the seminal case, Katz versus the United States from years ago, Justice Harlan's concurrence stated what's been termed the two-pronged test with regard to determining whether or not we have a reasonable expectation of privacy in a particular incident or situation. And it's essentially is whether or not the individual has a subjective expectation of privacy in the area or thing that's searched, and whether or not society deems that expectation to be reasonable. So it gets kind of circuitous if you think about it in terms of if, as you've pointed out, that if our expectations are slowly being diminished every day, the government can determine where and under what circumstances we have an expectation of privacy. We can't drive down the street without, multiple cameras indicating where we're driving along the street. If you get enough tickets like I have, you finally come to the realization that there are cameras there. So now I'm being dictated to me in terms of what my expectation of privacy may or may not be. So it gets kind of circular after a while.
Questions? Yes.
I guess I had trouble understanding, like, it seems to me practically that most people would give up their right to potentially catch serial killers and serial rapists. So I guess I'm just wondering if you have any hypothetical situations that come to mind for you for, like, bad actions the government could take if we keep allowing this. But I guess I'm just having trouble understanding practically why this isn't, like, a great thing for
Well, I think the...
and not mine.
I think again, there's to say that there isn't that this just seems like a really good thing. It's true. I mean, the law enforcement now has the ability to, catch people that have been skirting the law system for so long. But for those people and really the relatives who are unwittingly putting their DNA, thinking that they're only deciding, okay, I'm going to go find my long-distance relative who's in England. That's great. But at the time when they're doing that, they don't necessarily know that law enforcement is now going to use that without their knowledge or their permission, we don't specifically know all of the information that they have. I know that for the Genetic Information Non-Discrimination Act, that specifically, there was an article that was actually written in the journal last year that dealt with how some of these databases, employers are now using them to discover whether they have pre-existing conditions, anything like that. So that information is also accessible to law enforcement as well. And that's just something that we as consumers, when we're doing this, have to be wary of.
Is it true also that you assumed it for this purpose, being used for a good purpose, for catching these people, but also that it could be used for manipulation of that DNA, or that it could be used in actuarial purposes or something like that, things for determining that you had, and I guess that's the thing that I'm sure I want them to catch and kill
Yes.
her, but I don't
think everybody
want them
would.
to use it to make Frankencorn with my DNA turned into that, so
Yeah.
that kind of thing. We're not really sure about what all the uses you're surrendering for yet.
Right.
And some of them may be dubious. Anyway, yes, and then
Sorry, so this might be a stretch, but if we somehow found a way to have people informed, which seems questionable with many things we say I'm informed about, couldn't this be compared to a giant exclusion list? Like, people frequently give up their data to be excluded from crimes, so could we not, people have that choice to give up their information to be saying, I want to be excluded, and how does that tie in to saying, people have the ability to do that, so why can we not use a list like this that's people excluding themselves?
And that's actually something that GEDmatch has started employing with this opt-in feature. And I think that that's something that the DNA website should have too, because then people are actually saying, and it's written in bold, okay, I'm disclosing my information, versus Family Tree DNA, where they used all of these, they solved 10 crimes, sure, but they did not let their customers know that they were using their DNA and submitted these profiles to the FBI.
Just to follow up on the food corn, are these companies allowed to like replicate DNA and then like actually use it, or what are they promising only to sequence it so that they can create these profiles and then
Yeah,
Clone me?
I mean, I didn't find any websites that did that. The websites that I focused on were Ancestry.tree.com and Family Tree DNA, these websites that just give a profile of your lineage and your ancestry.
so they like explicitly promise.
Yeah, they'll tell you
not
like,
gonna do.
they'll say like, okay, you're 50% of your Asian descent or 30% something else, and then link you up with long distance relatives of like, oh, you have a distant cousin that lives here, and then you can communicate with them. So there are some cases, I know, I didn't write about those in my article, but there are cases where, you know, adopted children find their parents, but that also poses a different layer of privacy as well, where these adopted families have asked for a closed adoption, and then they're discovering their identities that way, which is a totally different angle of the article that I did not explore. So,
We'll just come on around. Go ahead.
One question I have is just that, is there any analog to the way we do it normally, where if I dispose of this cup, even if they know I'm not the suspect, but it could be a family member, they can grab my cup and test my DNA, check?
well, I think at that point, you've abandoned that DNA if you've thrown it out.
But, like I'm saying that, yes, I abandoned it,
Mhm.
but then they know I'm not the suspect. And they actively get the cup to see if a family member could be.
So that's actually interesting, because that goes into one of, there's been one of 3 states already that have brought in precautionary measures to familial testing. So if they knew, for example, you had a long distance family member that committed a crime, and they suspected that person, but they had your abandoned sample, Maryland has put in a state law that says that you cannot do familial matching, so they wouldn't be able to do that.
You can't hunt the relatives.
Yeah. Yes, there's one of 3 states that do that right now. But then you have on the flip side, I think through was it the Fayetteville one, where in Arizona they have a law that allows that. They're one of 11 states that does allow it. So.
So my question, and it's almost not a question, but it's so it wasn't an argument you were making. It was one that you. It was more your opposition. If people are saying that it's a good thing that these databases are now open to, you know, police using for these cases, whether or not it's just to add, in some cases, like now we have more white people in our collection. At a certain point, you have to just say, why not go all out and just have a complete mandatory DNA database of everyone who's born?
I mean,
What's the argument against that?
I personally would not want that, but
Which has been proposed by Arnold Lowy down at Texas Tech. He's written an article just to, you know, so. I'm breaking up in hives. Yes.
If that's your argument, that's
It's
where it ends up.
yeah, I would agree.
So what's the,
Certainly, and that's certainly one of the fears. And the general answer to the question of why should we care is exactly that, in terms of a slippery slope, in terms of, you know, our expectation of privacy. Because I think we all agree that there are aspects of our lives and our possessions and certainly our genealogy that we have not only a desire but a right to keep private from governmental intrusion. And every step that we take, if we're going to engage in a balancing and just generally say, well, it's a good thing to catch murderers, so therefore it's okay, there's a contrary argument to that as well.
Yeah, I did have a question, but I just wanted to say, going back to the whole, like, what's so bad about this? I mean, I think that is exactly the point, that if, you know, those who object to this practice are not saying, well, we don't want to catch killers, right? The concerns are more about, well, where is the sphere of autonomy for law-abiding citizens? And people who have committed crimes might be incidental beneficiaries of a privacy-focused practice, but that's not the target, right? My question for you was, first of all, thank you for this
can or will resolve, or do you think it's something that Congress will have to look at? I mean, my read of the recent Supreme Court cases in this realm is that the court doesn't really know what to do with these issues when it comes to the third-party doctrine. It's sort of like, we didn't envision this in 1967 and 1979, you know, so.
Yeah, I mean, that was something that I really struggled with in my research, was finding cases that specifically dealt with this, because again, they don't really have standing under the Fourth Amendment, so it's hard to find, it was hard to find cases that dealt specifically with an injured party whose information was taken from a DNA website, and then they were eventually brought to trial with, unless it was like the Golden State Killer, which again, he should be, you know, arrested and convicted. I think it'll probably be something that comes up sooner rather than later. I imagine that it would, because so many, I think there's, over the past, I think since 2016, it's been something like, it's now become like a $20 million industry, specifically here. So I think that that's just something that eventually it will be at the Supreme Court. So, are there any other questions?
One more question? So I just want, I know this, there's the public-private, but is this somewhere where maybe like police would have to get a warrant in order to?
Well, and that's the thing, is that in all of the cases that I cited, the Golden State Killer, the North Carolina, they did not get warrants, they just did it. And there's no legislation, no sort of like oversight on how to manage that. So, and now these terms and conditions are saying that some police, like GEDmatch, they don't have to do to get a warrant. So that's just something that I think we should also think of as consumers as well.
Thanks.
Thank you all for coming. It's a great presentation. Not be complete without a plaque with Claudia's name on it. So thank you for being our first student scholar this year. Thank you, Professor Zackham. We'll be back February 12th with Rebecca Schisler, who will present on environmental topics. So thank you again.
Thank you
all.
very much.